otherwise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Koehler, and I invite you to my next FCPA Institute in Miami on January 12th through the 13th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute.
Welcome to FCPA Flash. This is Professor Mike Koehler, and in this episode I am pleased to have Martin Weinstein as a guest. Mr. Weinstein is a partner at Willkie Farr Gallagher, where he heads the firm's compliance and enforcement practice group. Martin is a veteran of the FCPA bar and has decades of experience in FCPA and related issues, including as a former assistant United States attorney in the fraud section of the Northern District of Georgia, where he was the lead prosecutor in the Lockheed FCPA case. Thanks for joining us today, Martin.
Thanks, Mike. Great to be here.
And I should also add, in the interest of full disclosure, that I used to work with Martin at our prior law firms. And indeed, many of the stamps in my passport are due to Martin sending me around the world to investigate FCPA issues. So thanks in many respects for being an FCPA mentor of sorts.
Oh, that's great. It's really fun to think back on it. That's fabulous.
2016, obviously there's a couple weeks left in the year, but at this point has already been a very active and interesting year for FCPA enforcement and related policy developments. And in today's podcast, I've asked Martin to sort of identify his list of the top 3 to 4 issues from 2016 and why these issues are important. So let's just start with your list, Martin. What do you think are some of the most important issues in this space in 2016, and why are these issues important?
Well, Mike, I came up with 3 or 4 issues that I thought sort of topped the headlines for the year, and I'll list them and then we can go into them in detail. My first one was the pilot program, the implementation of a pilot program which dealt with some level of amnesty and some level of cooperation, and I thought we'd talk about that a little bit. Then the second one I had was the specifics, the department getting more specific in its expectations for credit for cooperation. But my third issue was increased foreign enforcement and cross-border cooperation. And then my last issue was cases being brought in areas that were not traditionally thought of as FCPA bribery areas, but now seem to be generating enforcement actions by both the SEC and the DOJ. So 4 big issues and a big year, as you say, 2016, a pretty big year for FCPA.
Yes, well, let's start at the top, and just for the listeners' benefit, in April of 2016, the DOJ released its so-called pilot program. So take it from there.
So this is really the first of its kind. It's fascinating that you can have in the context of a criminal statute a pilot program that lasts for 12 months, when in fact, the statute obviously began before April 2016, and it's going to go on after April 2017. But the primary purpose of the pilot program is to encourage companies to come in and make voluntary disclosures, but to offer them in exchange greater transparency on how they can get declinations or get cooperation credit. So under the pilot program, a company must meet 3 requirements to qualify for full mitigation credit. 1, it must voluntarily self-disclose its FCPA-related misconduct. 2, it must fully cooperate with the government's investigation. And 3, Where appropriate, it must remediate flaws in its internal controls and its compliance program. And a company must disgorge all of its profits from its FCPA violations. So if all those are met, the Department of Justice will consider declining prosecution altogether, which obviously is a big benefit. But if a criminal resolution is warranted and it's not quite clear when one is a declination and another is criminal prosecution being warranted, if criminal prosecution is warranted, the Department of Justice can provide up to a 50% reduction off the bottom end of the sentencing guidelines fine range and forego a monitorship. So there's some carrots, there's some sticks, there's a little bit of uncertainty, but a little bit more transparency than we've seen in the past. So that's a big deal. They've used it a few times, but it's a little bit of a pilot project, as they say, and I think it's one of the big takeaways of the year. I mean, they're committed to treating companies that don't voluntarily disclose more harshly than before. On the other hand, if you do voluntarily disclose, there are some benefits. Remediation, including discipline of high-level employees, so that's another theme we've seen floating around, is looked at much more carefully. And cooperation, which is now much more clearly delineated, is again a big factor. So putting some structure into how declinations are provided, this pilot program, I think, is one of the big takeaways, one of the big issues of 2016.
As you mentioned, the pilot program has many different factors sort of embedded in it, and some of those factors, such as encouraging companies to voluntarily disclose, wanting to bring individual prosecutions, rewarding a company through a smaller fine and penalty amount if they disclose and cooperate, weren't exactly new developments in the sense that the DOJ has been articulating these factors and presumably acting consistent with these factors long before the pilot program. So what do you think was the motivation of actually putting this into a single document, putting a title on the program, given that the DOJ was doing many of these things, even prior to April of 2016?
Yeah, I think, Mike, it's very specifically companies or corporate actors, as well as practitioners, just didn't have a sense of certainty. There was a lot of it was anecdotal. A lot of people like myself who practice in the field every day had a pretty good sense of this, but putting it down on paper gives corporate clients and practitioners something to actually hang their hat on, something more clearly delineated. And I think that level, what clients and attorneys are looking for is some level of certainty, some ability to make a rational risk assessment, and I think putting this on paper gives them more of an ability to do that.
Well, you mentioned some of the, well, at least generically, some of the actions, and just for listeners' benefit, thus far the DOJ has self-identified 5 matters as fitting under the pilot program. Yep. There were 3 so-called declinations, Nortec, Akemi, Johnson Controls, and then more recently, really a new way, all things considered, for the DOJ to enforce the FCPA, and that was the so-called declinations with disgorgements in the HMT and MCH matter. Do you think that these declinations that the DOJ self-identifies under the pilot program, that they'll be more frequent or less frequent as perhaps we move into a new administration?
Well, it's hard to predict what's going to happen in a new administration, and the pilot program, by its own definition, runs out around the first quarter or April of next year. So, what's going to happen with that, I can't begin to predict. What I can say is that if the government wants to continue to incentivize voluntary disclosure, they're going to have to continue to publicize when they make declinations, because obviously one of the things that companies are looking for, and they see it in the antitrust field with the antitrust division, they're looking for some level of certainty. If we do X, what are the various things that can happen to us? And they want to have some level of certainty that if we do X, a declination is a real serious possibility, and the declinations actually are being given out. That's the motivation, because making a voluntary disclosure not when it's a mandatory disclosure, but making a voluntary disclosure. That's an extremely hard decision for a company. Extremely hard.
Another issue you had on your top issues list was increased expectation for cooperation. Can you elaborate on that a bit further, recognizing that you've obviously been interacting with DOJ and SEC enforcement officials on behalf of corporate clients for many, many years? What do you think has changed in that space?
Well, my hair used to be dark when I started, and now it's all white. So that's definitely changed in the last 20 years. But I think the biggest thing changed, aside from hair color, is that I've been doing this a long time. Is the reality that the Department of Justice has continued to evolve in what it calls cooperation. And Mike, when you and I were working together, cooperation involved, providing documents without getting a subpoena, trying to make witnesses available, going in and talking to the government. The bar for cooperation has ratcheted up much higher and continues to be ratcheted up even higher. And I think it makes the job of being a defense lawyer or a corporate or attorney to advising corporations, and also somebody who's cooperating with the government, it makes that line, doing both those jobs, harder than ever. Let me give you some examples. So there are 11 specific metrics that have been identified to receive full cooperation. I'm going to give you some of the notable ones. Preservation, collection, and disclosure of relevant documents and information relating to the situation. I've always thought that that's pretty standard. There's nothing new about that. This second one, deconfliction of your internal investigation with the DOJ investigation, that's kind of new. So we've seen recently where the Department of Justice has said, tell us who you're interviewing internally in the company, and if you will stand down and not interview person A, B, and C, we want to interview them first. So it's a relatively new, in the last year or two, approach by the Department of Justice to say to the practitioner, don't complete your internal investigation. Don't interview certain people before we do, because we want to get first crack at them. That's new, and that makes the line between being an effective counselor for your client and cooperating with the Department of Justice a little bit harder. Providing a third factor that I've picked out is providing all facts relevant to potential criminal conduct by all third-party companies. So now you're not only talking about what you've done, but talking about what other companies have done. Making available for, fourth one that I thought was interesting, making available for interviews company officers and employees who possess relevant information. And that sounds relatively easy, but in the Foreign Corrupt Practices Act area, remember that a lot of these people are not U.S. citizens. So you're juggling all sorts of foreign laws with your interest and desire to cooperate. So people from other countries may not have, even though they're your employee, they may have protections under the laws of their countries where you can't necessarily have the same impact on them as you could if you had an employee here in the States. And so you're trying to make those folks available. At the same time, you're trying not to violate local law. And I think that's a bit of a challenge. You're also asked to disclose all relevant facts gathered during a company's independent investigation. This has always been a bit of a tightrope between not wanting to waive the attorney-client privilege because there's so much civil litigation around FCPA issues, but still wanting to convey the facts to the government. This question about how you invoke the attorney-client privilege and still get the facts to the government, I think it's become more challenging. I think the government, as they look at individuals, including in-house lawyers and folks like that, they want to know the facts. You want them to know the facts, yet you don't want to waive the privilege. And I think that's a tightrope that's been pretty tough. You've seen in some recent settlements, some of these issues have been highlighted, and I think that it continues to be a challenging yet fascinating and really interesting area for a private practitioner to be in, because the bar, the quote-unquote cooperation bar, continues to be raised. The stakes continue to be higher and higher in these cases, and you as the practitioner have to apply your skill set to achieve both an effective result for your client, protecting its various rights, advocating on its behalf, but still cooperating with the government. It's a bit of a challenge. It's not for the faint of heart.
Do you think the bar has been set too high in some instances, recognizing that at least traditionally criminal law enforcement was, sort of an adversarial relationship between the prosecutors and the company and their counsel. Do you think the bar, perhaps on a couple of those factors you mentioned from a public policy standpoint, has been put too high? And how do you deal with that as a practitioner if you're getting these instructions or wanting to best position your client, but perhaps getting some pushback from the corporate client itself?
Yeah. Well, first of all, my approach to things going back many years when I was a prosecutor was, while we were technically adversaries, I'm really proud to say that many of the lawyers who were on the other side of me, including people like Larry Thompson and a number of other folks, we were really good friends. There was professional advocacy, but out of the courthouse, I really considered them friends. I think in many ways that collegial relationship is still there, but obviously there's a little more pressure on it. I'm not a big fan. I think cooperation is really important, but I'm not a big fan of the government saying don't interview certain people, which I think inhibits our ability to properly advise our client. I'm not really a big fan of things that deal with the attorney-client privilege, which I think allows us to protect our clients and also collect information. I think the situation's gotten a little bit worse in the sense that now really companies can't afford to be indicted for these kinds of violations, and so the government holds the big sledgehammer and all the cards. And I think now that they have all the cards, I'm a little bit unhappy about some of the limitations they're putting on lawyers, defense lawyers, because we really don't have much in the way of recourse. In most of these cases, if you have a problem, you're going to be forced into settlement. Litigating these cases is really not a viable option in a lot of places, a lot of situations, and so that gives the government kind of a heavy hand, and I worry that maybe the hand's getting a little too heavy.
Another top issue from 2016 you mentioned is the reality that the world is becoming a smaller place with each passing year, and that obviously is relevant to FCPA investigations and cross-border cooperation, as these types of cases usually involve, almost by definition, conduct in multiple different jurisdictions. So could you elaborate a little bit more on what you see as the increase in foreign enforcement and cross-border cooperation between the DOJ and some other law enforcement agencies?
Yes, some of this I think is really fantastic. And when I look back on my days as a prosecutor, when I was, trying to gather evidence internationally, and it was really, really hard, I think of some of it as great stuff. Some of it causes me some pause. I'll give you some of the things I think are good, and some of the things that give me a little bit of pause. So we have a number of other countries now enacting anti-corruption laws. Mexico enacted one that goes into effect early next year. South Korea, and France, of course, a new anti-corruption law on November 8th, 2016, which is great. I think all these begin to expand, level the playing field, move forward in terms of having a level of enforcement that's not just U.S.-centric. And I think that's really important for an international anti-corruption effort, so all good stuff. On the other hand, I kind of worry that there's been kind of now that FCPA cases generate so much in the way of fines and penalties and disgorgement, that there's sort of been a rush to generate revenue, because one thing that all governments like is revenue. And so we had in the Vimpelcom case $397.4 million to the U.S. government and $397.5 million to Dutch prosecutors. To me, I understand the U.S. being the regulator, but most of the time the U.S. government is not the victim. It's some other government and some other non-U.S. entity or parastatal entity that's been the victim. And yet the U.S. government seeks the disgorgement, gets the fine, puts it in the U.S. Treasury. It's been a pretty good moneymaker for the U.S., but ultimately most of the victims are not U.S. It's not the U.S. government. Now, I understand the theory behind this, and I'm glad that other countries are getting involved. I get a little worried about the chase for revenue here. I think it's driving the fines up way higher than they should be. I think many of these fines, you know, the idea that a case that I had in the 90s when I prosecuted, you know, you mentioned Lockheed, you know, 99.9% of the people in Lockheed Corporation were good people. And there were a few people that did some pretty foolish things, and the fine, I think, was $24.8 million. That stood in the top 10. That was the top fine for many, many years, and it stood in the top 10 for, I don't know, you know, maybe a decade. Now it's probably not even in the top 30. And the question is, has bribery gotten to be so much more profitable, or was the government just taking a harder line? I think some of these fines are just way too large. And the amounts of revenue and the amounts that have been taken out of innocent shareholders' pockets and companies' pockets, you know, in some cases I get it. In some cases, it seems to me to be disproportionate. And I think a lot of governments now are in the business of chasing the revenue, and that causes me a little bit of concern.
Well, needless to say, I completely agree with what you just said, and I've written rather extensively about this, how FCPA enforcement has come a long way in a short amount of time. And with some of these settlement amounts, you're sort of left scratching your head as to how a 2016 enforcement action that settles for X dollars compares to what I think is a factually more egregious enforcement action from 5 years ago that settled from a fraction of that amount. Yeah. And I'm glad you mentioned this, because obviously bribery, however we define it, is bad, but I think there's a mindset amongst certain relevant actors in this area that just because bribery is bad, therefore any and all attempts to prosecute bribery offenses, regardless of the resolution form, regardless of the ultimate fine and penalty amount, represents an inherent good. But as you rightly note, and your comparative perspective on this from being at the DOJ and having helped clients in this area for many, many years, is informed, and I appreciate that candid perspective. Now, another thing related to this, of course, is the OECD Convention, of which the United States and approximately 40 other countries are party to, contemplates this. And I know it's sort of non-binding, fluffy guidance in many respects, but even the OECD recognizes this and encourages companies to work together to have the most appropriate split. Do you see that, the letter and the spirit of the OECD guidance on this issue being played out in practice?
You know, I'm a big fan of the U.S. not being the world's policeman on international corruption. I like the idea of the UK being more involved. I like the idea of France being more involved. I like the Dutch being involved. I think this is all good stuff. I think the U.S. being the policeman creates problems for the U.S. Companies don't want to list on our exchanges. I think it's an anti-business position to be in. So I'm glad that others are taking that position, particularly if they have a proper rule of law. So if you have a proper rule of law and you're going to get fair adjudication in that country, I think that's all good stuff. Where I struggle on these kinds of issues is when the U.S. starts taking positions that effectively are administratively creating precedent. So one of the interesting things about the U.S. as we talk about FCPA is that FCPA, what we would traditionally call FCPA jurisprudence, incredibly thin. All the cases we cite and talk about, none of them are adjudicated by judges. They're all settlements. And somehow these settlements between the government and private companies and their counsel have become considered the equivalent of jurisprudence by federal judges. Now we have, for example, and who's a government official case? What constitutes government? We have one decision by the 11th Circuit. That's good. Judge decisions are good. That's what judges are there for. But then we have all these other cases that are settlement-created jurisprudence, and that has sort of become the stepping stone for broader and broader and broader types of enforcement. And I think that's an issue, because when we start citing settlements between companies and the government as jurisprudence, and the U.S. government is the primary enforcer of the law, you have a system that can really get too over aggressive, too expansive, and I think that that's something we should watch more.
Yeah, prosecutorial common law, and you effectively sort of restated the thesis of my 2010 article, The Facade of FCPA Enforcement. And I think the issues you just talked about, I'm guessing probably tie into your last big topic from 2016, and that's continued expansion of enforcement actions outside of traditional sectors or traditional forms of bribery. Can you elaborate on that point a bit further?
Yeah, I think so. For example, the sons and daughters case that came out of J.P. Morgan Chase, which you've seen sort of come out in different forms with Qualcomm, you saw it in BNY Mellon. That's a really interesting area for me because obviously that's conduct that we're not looking to condone. But a $72 million criminal penalty by J.P. Morgan and a $130 million penalty to the SEC, that's a lot of money. Now I understand how they calculated it, but when we look at the statute, and remember it's a criminal statute, so it's supposed to have quite a bright line test. When you look at the criminal statute, you don't see anything about sons and daughters. You don't see anything about joint venture partners. It's a fairly I wouldn't say vague, but there are a number of specific elements to it, and those elements have now been interpreted so broadly by basically what I would call administrative or Department of Justice SEC created law that we now have an extremely broadly enforced statute which Congress hasn't really spoken to. I mean, if Congress wanted the statute to be enforced in such a broad way, with disgorgement going back beyond the statute, with officials of quasi-privatized enterprises still considered to be government officials, then I would think that Congress would want to amend the statute. But that's not what's happening here. So you ask yourself, when the government had the takeover of the U.S. auto industry, was a mechanic at Chrysler a government official during that time period? Because the U.S. was basically running the auto industry. And so we ask ourselves with regard to non-U.S. businesses, whether in China, Russia, elsewhere, are these state-owned enterprises that function as private enterprises in terms of the business community, are all those people government officials? Now, that doesn't mean that the companies should be doing and engaging in all sorts of malfeasance. Don't get me wrong. But as a lawyer, I ask myself, if we're going to be punishing people for criminal violations, punishable by going to jail for extensive periods of time, shouldn't we be creating more bright line tests, either by amending the statute through Congress or by having judges make decisions that create jurisprudence, real jurisprudence, that's been something that's been before a judge instead of before a prosecutor? And so I'm not opposed to expansion of or prohibiting improper conduct. I'm all in favor of prohibiting improper conduct. But I think when it's a criminal statute, punishable by huge amounts of money and sending people to jail, the expansion of the statute ought to be done either by interpretation by a federal judge or by amendment by Congress, and not administratively or de facto by prosecutors who candidly spend a number of years in the government and then go on to private practice. I think it's a haphazard way of expanding things. And I think it can lead to some extraordinary results, and that's something I think we need to watch going forward. I think it's a fascinating area. I enjoy practicing it. Enjoyed practicing it now for almost a quarter century. But I worry that its expansion has gotten a bit far. And I think, again, if you don't have a bright line test, it puts companies in a hell of a position to understand exactly where the lines are. And if we're going to continue to blur the lines and change the lines on a pretty regular basis, I think it's not really fair, honestly.
Yeah, I'd just like to elaborate on a couple of those points and be happy to hear your further comments. Obviously, the state-owned enterprise issue was the subject of an 11th Circuit decision. I think that was a highly flawed decision. And to your earlier point, show me another area of law in which an issue is deemed to be decided just because there's been one appellate court decision on an issue. Another issue that I think is very much in line with what you just said, There's been now approximately 25 FCPA enforcement actions based upon things of value given to physicians and other healthcare providers. And the final comment, and I'd like to hear your thoughts on this, is regardless of liability, and this goes into your settlement amount observation, there seems to be assumed causation in nearly all of these enforcement actions. In other words, the only reason this pharmaceutical or medical device company received the business was because a Chinese doctor went to a karaoke bar. The only reason J.P. Morgan got on these deals is because a so-called princeling was hired as an intern. Do you think this assumed causation, which is very relevant to the disgorgement amount, needs more proper analysis, because that is what is driving the settlement amounts in many respects of the disgorgement amount?
Yeah, well, you and I are saying some of the same thing and disagree on some of it. So I thought the Esquenazi decision was interesting. I'd like to see 10 more decisions that interpret government officials, and I think then we have a level of jurisprudence. I'm not down on that decision. I thought it was interesting. I'd like to see more. I'm always interested in reading cases on the topic. I agree with you entirely that I think that when the government is saying, well, if it weren't for this, then J.P. Morgan wouldn't have gotten the business. Or if it weren't for this, then X, Y, and Z company wouldn't have gotten the business. Therefore, we're going to book all of the profits from that as tainted. I think that's overly broad, so I'll say it a different way. If some of these companies had been convicted and had gone before a judge in a sentencing hearing, I think the judge would not have sentenced them to the same amounts of money that they're paying now. I do believe companies are fundamentally overpaying to avoid being charged. And I think that the government, because it has this huge leverage, needs to be more careful, more judicious, more thoughtful in how it's booking revenues, and not looking to have earnings calls like publicly held companies. I believe that many of the organizations that come in and engage in cooperation are being booked in terms of disgorgement at higher values than is appropriate, because I do agree that there are a variety of reasons why business is given out. Some of it may be improper, but I think to book all the earnings from a transaction and say if such and such hadn't happened, they wouldn't have gotten any business, I think that goes too far. And I think that goes farther than a sentencing judge would go if the company was before them following a conviction. And that's something I think we should look at. I think the amounts of money have gotten too high.
Well, no doubt 2016 has been an interesting and active year, and today's guest has been Martin Weinstein, a partner at Willkie Farr Gallagher, a veteran of the FCPA bar. So thank you, Martin, for sharing your candid insights and observations about the top issues from 2016.
Thanks, Mike. My pleasure. Happy holidays, everyone. See you all in 2017.
Thanks, Martin.